Thank you for those of you who joined us promptly today. Just gonna wait another 30 seconds or so for others to join. Thanks for your patience. Good morning, good afternoon, and good evening. On behalf of Baker McKenzie and the Global Litigation Group, welcome and thank you for joining our final webinar in the series on digital and cloud technologies, evidentiary strategies. My name is Marcela Trigo, and I'm a partner in Rio de Janeiro, Trent Ross Watanabe, and I'm delighted to be hosting this webinar today. For this session, I'm joined by my Baker McKenzie colleagues from across the globe. Ben-Shin Lee, partner based in Baker McKenzie Finchung, Shanghai. Helen McPherson, partner in our Sydney office. Mackenzie Martin, partner based in our Dallas office. And Alexander Heater, partner based in our Munich office. Moving ahead to the agenda, during the next 60-minute webinar, we'll focus on key issues to consider when gathering evidence on a cross-border basis, how to lawfully investigate whether there has been an actionable patent infringement, and key mechanisms available for obtaining evidence on a cross-border basis, and support of patent litigation. Before we get started, I just want to remind you of a few housekeeping notes. To ask a question, please use the Q&A button at the bottom of the screen. We'll address questions in the end of the presentation, and we'll do our best to get all answers. But if we don't have time, we'll be back to you by email. During the session, we will have 4 pool questions to comply with CLE and CPD requirements. If you wish to obtain CLE and CPD credit for taking part of today's session, please answer all 4 pool questions promptly. Instructions to obtain CLE and CPD credit will be provided in a separate communication to you. The US CLE code will also be flashed towards the end of the session. Lastly, this virtual session is being recorded, and some of us are presenting from home. So while we are all attempting to create a studio-like atmosphere, please forgive us for any background noise or doorbell. We are trying our best during these challenging times. So before I turn the mic to Alex, I'll start us off with our first polling question of the day. What measures does your company usually take to protect your technology? Wait a few seconds more and then I'll close the poll. Wow, all the above as the one with most hits. Yes, this was not surprising to me. So now we can start and the word is yours, Alex. Thanks.
Thanks, Marcela. So today we will speak about means on how to obtain evidence for software patent infringement proceedings. And this has a factual, a technical side and a legal side. And we will start with the technical means. And here, before we go into the detail of the different aspects for the different evidence that can be obtained, I would like to go a little step back and explain a little bit about what is source code, what is object code, how have program paradigms changed, and why this is relevant for the questions we are facing. Next slide, please. So, as you know, a processor can only handle like zeros and ones. And originally, computers were programmed this way. So there are specific patterns of zeros and ones which cause the processor to perform a specific action, like adding two numbers or subtracting numbers or whatever. And this way of programming, of course, for humans is not convenient. And therefore, some kind of evolutionary process has started. So in the first step, those patterns of zeros and ones causing the processor to do something, very small steps, were replaced by mnemonic low-level commands like add or JMP, standing for jump, like you see it here on the right-hand side of the slide. And then this assembler language was used to program stuff like, I don't know, MS-DOS up to version 5, I think, was programmed really in assembler language. And it was also used to program programming languages, which enable programmers to speak to the computer in a way more human-like way. So for example, a classical program is when you start learning a programming language is there's the text hello world is presented on the screen. Yeah, when in assembler language, you might need some pointer to a piece of memory where this hello world string is placed, and then you have to somehow move it in a register and call an interrupt and all of this. And in a more high level language, you write something like print hello world. And then in the background, by a program called compiler, this is translated in those patterns of zeros and ones, which actually are doing the job. And here, the first generation of programming languages like C, for example, were still, let's call it close to the wire, still very hardware oriented. But here again, things have developed and more complex program aspects like object-oriented programming, etc., have come into place, which is relevant because, as I said, when you are writing source code in the computer language, which you, the human, understand, this is transferred into object code by the compiler, and this process of compilation can be reversed, at least to a certain degree. And this degree depends on how much additional information, which is useful for us humans, has been cut away during this act of compilation. And here, the more modern programming languages all have it in common that a lot of information is indeed maintained. So when you look here at the examples on the slides, it is with a more advanced programming language, more typical or more to be expected that if you decompile something, you receive a result like the one in the middle, which still is very similar to the original source code, while with the close to the wire languages, it might be that you just receive a result like it's on the right-hand side of the slide, where you indeed still need put a lot of effort into reading this. This comes hand in hand with the shift of program paradigms. So originally, the main paradigm was efficiency, to get as many bytes for a buck as possible, which means high compression, everything very efficient and no metadata to be maintained. And the new paradigms are like reusability, modularity, and corporation of software modules, which indeed leads to also compiled object code, which maintains a lot of meta information and therefore facilitates the reverse engineering. Next slide, please. So with this in mind, I would like to go through typical sources of evidence when we are talking about software. Here, the first one, like presentations, publications, this can be anything like, for example, advertising materials. I think this is a straightforward point. Another point is standards. Here, for example, mobile devices need to communicate with each other, and this kind of communication is standardized. Or this is also happening in the field of, I don't know, audio, video codecs. A lot of fields actually have this. And when you have a standard, you can be maybe in the very as a patentee positive situation that you do not even have to look into the software, but that you look just into the standard. And if you can argue the case that the standard necessarily makes use of your patent, and if a product is implementing the standard, then you can derive that the product is making use of the patent. So you do not read the patent against some software which you need to reverse engineer or whatever, you read it against the standard. Next on the list is external behavior, graphical user interface. Here, this of course depends on your patent. If you have patents in this domain, then maybe the question of patent infringement can be assessed quite easily by just looking at the product. Like, you know, the famous slide to unlock patent. I mean, here it is no rocket science to assess whether a device is making use of this or not. And we have documentation. This here, as I said, goes hand in hand with increased collaboration of software modules. This often leads to also a more sophisticated, more detailed documentation of the software, which maybe, again, depending on your claim language, can already allow for assessing whether a patent is infringed or not. And if not, we need to go into the domain of software forensics. Here, of course, we have open source software. Of course, here we do know the actual source code, which is here the holy grail, because we exactly know what the program is doing and therefore can easily assess whether a patent is infringed or not. However, if the source code is not available, we need to somehow find out about what's going on. And here, one mean can be black box testing. Black box testing means that you do not actually touch the software, but that you take the software as a black box and that you feed it, for example, with specific input values and see what output values are calculated, how the software is behaving, runtime, what's happening with the memory, etc. And a specific way of black box testing can be seen when looking at the interfaces. Here, I mean, like, as I said, software now is collaborating, it's exchanging information with each other. And if you can somehow observe these interfaces, you know what information is exchanged between the software modules, which also might allow you to assess what's actually going on within the software. And last but not least, we have decompilation, reverse engineering, which I've just talked about the prior slide. Next slide, please. With this in mind, I would also like to make a few comments on in how far the software forensics, this analysis is legal. Here from a German and European perspective, I can say that trade secret law is not so much an issue, which is because we have in Europe a trade secret directive, which explicitly allows reverse engineering. When it comes to copyright law, it's a little bit more tricky because you need to go into the specific jurisdictions. Pardon me. Here, in a nutshell, I can say that black box testing is generally allowable because there are provisions, at least from a German point of view, in the German Code of Copyright Law. When it comes to reverse engineering, it depends on the circumstances because there are provisions which allow copyright infringement if it is for use in court proceedings, and then it depends in how far you already have some indication that your patent might be infringed and how far you're already willing to conduct court proceedings. And as to criminal law, this again depends on the circumstances of the case. For example, whether you need to breach encryption in order to obtain the information. And with this being said, I hand over to Mackenzie.
Thanks, Alex. So from a US perspective, our trade secrets laws come in the form of both state and federal laws, but typically reverse engineering would not be actionable under either state or federal trade secret law. Much less, looking at publicly available materials as Alex described, which would certainly be allowable. In terms of copyright laws, to the extent any investigation would involve some kind of copying of source code, there can be some fair use exceptions to provide a baseline level of protection under copyright laws. but this would be a highly fact-specific inquiry with judges weighing several factors. And so there's really no guarantee that that kind of investigation involving copyright would be permitted as a fair use. Additionally, reverse engineering involving copying for the purpose of litigation likely would not satisfy the Digital Millennium Copyright Act's more narrow fair use exceptions. And so US copyright laws can be a hurdle depending on how a software investigation is conducted. Setting IP laws aside for a moment, it's important to recognize that claims relating to reverse engineering of software often arise in a context where two parties are bound by some kind of contract. So for example, a vendor providing software to a customer under a license or another agreement would be a common arrangement. And typically a license like this will have a clause restricting reverse engineering or derivation or compiling or decompiling source code. And so contractual concerns should not be overlooked when considering software forensics. Last, US attorneys' ethical rules also prevent attorneys, of course, from engaging in conduct involving dishonesty or misrepresentations or inducing others to do so. And investigations that involve pretext can implicate attorneys' ethical obligations. So US counsel must be mindful of their ethical obligations when deciding kind of whether and how to proceed with an investigation, and forensic software analysis is no exception. So that concludes our comments on just pure legal considerations with respect to software forensics. Over to you, Benshin, for our next section.
Thanks, Mackenzie. So for this section, we will talk about the legal means in various major jurisdictions for the evidence collection. So let me start with China first. In China, plaintiff will bear the burden of proof as a general principle. However, the law also gave some room for the courts to shift the burden of proof based on the capacity for both parties to abuse the evidence, and also the probability of infringement along the trial. Also, considering the nature of software and cloud technology, the burden of proof is relatively lower for the plaintiff comparing with other type of patent infringement cases. And the black box approach has been openly used by the plaintiff, and the burden might be shifted to the defendant to prove otherwise. We have seen such kind of cases like Meigao versus Zhao and the Shougo versus Baidu in such kind of patent, software patent infringement cases. Next one, please. Unfortunately, China has no discovery approach for the parties to discover evidence. However, we have a couple measures for the plaintiff to collect and prepare the evidence for the trial. One is notarization, and the other one is judicial appraisal, and the last one is tax expert. And during the trial, there are also several remedies for the parties to use before the court. The threshold for each of the measures are a little bit different, so I'm going to go through one by one a little bit. For the evidence preservation, it's usually the threshold is that the evidence cannot be obtained by the plaintiff and might in danger of destruction or cannot be obtained in the future. So the plaintiff can plead before the court to preserve such kind of evidence by the court power. And the evidence submission order can be used when the written evidence is in the possession of the opponent and there are no other ways for the plaintiff to get it. And another one is court investigation order. That's usually used when such kind of evidence in the possession of a third party, for example, government authorities or any institution or a private company. And in such case, such kind of evidence may be kept by the third party as a trade secret or as a confidential information at least. So the plaintiff can plead before the court to issue such kind of order and then to collect evidence from such third party. The last one has been used quite oftenly in the tech-involved disputes is technical investigator. The investigator is actually appointed by the court, and he or she is supposed to provide the technical support to the court to understand the technical issues and also address any such kind of concerns. And also the technical investigator has the power to ask questions for both parties and also do the investigation by itself. So that's the end of my section. I would like to turn over to Marcela.
Thanks, Benching. So now turning to Brazil. First of all, I just want to clarify that Brazil is a civil law country. So most of our laws and rules regarding patent litigation and procedural rules also regarding evidence collection are not only in written laws, but sometimes in the codes of civil procedure and civil and criminal proceeding. Another thing, just as a preliminary note, is that in Brazil, patent litigation is both a civil offense and a criminal offense. So that means you normally have two paths to try to produce evidence and also to go after an infringer. And normally for software patent infringement, the criminal path is the one which is faster and simpler, not only to obtain evidence in a pre-litigation phase, but also to really get a fast result from a court, because we have in the law a way that the patentee can go to a criminal judge and request like a down raid, an order for inspection before even starting a case. So you can go to a criminal judge and request that the prima facie evidence you need to present is pretty low, especially in software patent infringement, because you will always have the argument that you cannot have that substantial evidence. So you would need the inspection to really close your evidence for actually deciding whether to pursue a patent infringement case, even in a civil case or a criminal case. So besides this criminal path, which is, as I mentioned, the easiest one, and it's normally ordered by the court that two experts go in the defendant's premises and do an inspection and even runs a forensic analysis if needed. We also have the civil paths, which are anticipated production of evidence, also inspection, and we also have the path of really providing evidence through expert opinions and trying an injunction without doing any further gathering of evidence. And in this case, expert opinions are key because we don't have US discovery type. So you would have to make your case and show and convince the court that you would have a likelihood of prevailing in a patent infringement case in order to get an injunction with expert opinions. Next slide, please. These are the legal requirements for both venues for trying an anticipated production of evidence, an inspection, or a PI with expert opinions before a civil court. As I mentioned, the criminal court has a lower bar, but before a civil court, you would have to show likelihood of success in the merits, irreparable harm, or risk of losing the evidence in the end. And you also need to show that you were not causing harm to the other party. So the court would not really be curing a harm with another harm. We normally call that balance of hardships or proportionality analysis, where the court will really look to eventually harm to be caused by the measure inspection. For instance, the court will normally see whether the inspection would cause defendants to stop their activities, or whether it will cause reputational damages, etc. And also the balance of hardship also needs to be done by the plaintiff itself before pursuing that path. We had a recent case where the only available venue to do an analysis for filing a patent infringement case was an inspection in a client, because the defendant was also serving the same client. So the client had to make an evaluation whether to really go for it and preserve the client relationship or not. So this is also a strategic decision to be made before asking for the measures such as an inspection. Next slide, please. Burden of proof. This is also addressed by Vincent in China, and I think we have very similar rules in Brazil. So the burden of proof will, as a general rule, lies on the plaintiff, but in a software case, normally the judge will shift that burden to the defendant, not only because we have a specific provision in our IP law and our Patent Act saying that for process patents, this is the rule should be exempted. So defendant must prove that he used a different process, but also because civil procedure laws would say that the judge can shift and will shift the burden of proof whenever the defendant has better conditions to prove that it does not infringe, then the plaintiff would have to prove infringement. So I think basically that's it for Brazil. And I'll turn to Helen.
Thanks, Marcella. So for Australia, I'm going to focus in on one evidence gathering process, and that's the preliminary discovery process. Now, to commence patent proceedings, patent enforcement proceedings in Australia, you need to be able to certify to the court that the factual and legal material available provide a proper basis for each allegation pleaded. And it's sometimes and even often the case that there's a missing piece or pieces, which means that you don't yet have a sufficient legal and factual basis to be able to commence those patent enforcement proceedings. So one thing that you can do is to apply to the court, and here I'm talking about the Federal Court of Australia, which hears the lion's share of patent enforcement proceedings in Australia. You apply to them for what's called preliminary discovery, rather than actually commence the patent enforcement proceedings and risk a strikeout application. Now, a preliminary discovery application is a separate court action from any later patent enforcement action that you commence. It involves applying to the court for an order that the prospective respondent, so the person that you ultimately intend to sue for patent infringement, that they provide discovery ahead of commencing a patent enforcement action. The jurisdiction to order preliminary discovery is considered to be an extraordinary one because it involves an invasion of the prospective respondent's private affairs in order to determine whether or not a case can properly be brought against them. There are 3 threshold requirements to get a preliminary discovery order. First, you have to show that you reasonably believe that you may have the right to obtain relief in the court from that prospective respondent. Secondly, after making reasonable inquiries, you do not have sufficient information to decide whether to start a proceeding in the court to obtain that relief. And the third requirement is that you reasonably believe that the prospective respondent has or is likely to have or has had or is likely to have had in their control documents directly relevant to the question whether you have a right to obtain relief, and inspection of the documents would assist in making the decision. Now, key issues to note about a preliminary discovery application are, firstly, even if you meet those 3 threshold requirements, the court actually has a discretion as to whether or not to order discovery. The court retains this broad discretion, and that's because of the intrusive nature of an order for preliminary discovery, where they take that into account. They also take into account the rule that this preliminary discovery rule is meant to be construed beneficially, so as to be given the fullest scope that its language will reasonably allow. A second issue to note is that you only need to prove that you have a reasonable basis for your belief. It's not a matter of which body of evidence should be preferred, Rather, it's whether you reasonably believe that you may have a right to relief. This requires the court to consider whether the evidence you rely on is capable of giving a reasonable basis for a belief about the matter. In the context of a recent preliminary discovery application in the patent area, the court said that the relevant question posed by the rule is not whether one scientific view, and here expert evidence was filed to prove the reasonable basis. They said, so it's not whether one scientific view is more or less persuasive than another. Expert views may differ about scientific points. However, if the prospective applicant has a belief that is founded on considerations or views that are reasonably open, even if contested as incorrect by others, that may well found a conclusion that the applicant has the requisite belief. The third issue to note is that you have to have a reasonable belief as to your entitlement to relief at the time that the application is being assessed. It's not sufficient that you have a reasonable belief that you may, at some time in the future, have entitlement to relief. And this again was an issue in a recent preliminary discovery application in the patent space, where the applicant's belief was contingent upon the prospective respondent at some time in the future deciding to launch its product in Australia. And preliminary discovery was being sought for documents which would show whether that product had been made overseas by the applicant's patented method, because if it had, upon importation of that product, there would have been an act of infringement. So that's where I'll finish talking about preliminary discovery applications in Australia. And before handing back to Alex, we'll do our next poll. So here you can see it on screen. Has your company been involved in any patent infringement disputes? Okay, so you can see the results, and it's a pretty even split between those who've been involved in patent proceedings because they've been enforcing and those who've been on the other side in terms of being enforced against. But we also do have quite a number who've not been involved or are not certain. So on that note, I'll hand over to Alex.
Yes, thanks, Helen. So now speaking about Germany and about legal means on how to obtain evidence for patent infringement proceedings, especially in the software space. The first slide says filing suit. Yeah, this is the first approach that you can choose, and maybe this is surprising because in Germany we have front-loaded proceedings, normal civil law proceedings, no pre-trial discovery, and typically in the writ of summons, you need to have everything together. You need to have a proper infringement allegation, which is substantiated. But however, in practice, the threshold as to substantiation is quite low. So if somehow you can make the case, argue the case that the patent needs to be infringed because otherwise this and that result wouldn't be obtained, or this and that method wouldn't work, etc., then this can be enough for a substantiated claim, and then it's up to the defendant to explain how actually he's doing it, because the defendant cannot just complain about the writ of summons saying this is not substantiated enough. The court will not hear this kind of defense, but the court will say that the defendant knows best about the product, and therefore then it's up to the defendant to explain how he or she is actually doing it. But however, and this might be relevant especially in software cases, if the infringement allegation is made on a kind of "it must be so" accusation, then the defendant can also maybe rely on a defense saying, yeah, but I have, it can also be differently. It can also be done that I, the defendant, am not saying how I'm doing it. I'm just suggesting that it could be also done in this and that way, which is not patent infringing, but leads to the results the plaintiff is looking at, the results with the patent, or is compatible to a standard or whatever. So this slide where I say filing suit is a mean for obtaining evidence, this of course needs to be considered very carefully. This is something to be assessed on the specific case, and it can be a good idea, but it can also be not a good idea. So, however, it is a possibility, and therefore here it's in the slides. And next one, please. However, if you do not want to take this maybe a little bit risky approach, but you want to play it safe, then German patent law also provides for inspection procedures. And here, when I say Germany, to a certain degree, this can be taken as a pattern for the rest of Europe, because the enforcement directive in Europe says that such proceedings should be available across Europe. Yeah, but here in Germany, the proceeding is as follows. If you consider your patent being infringed and the legal requirement is some likelihood of infringement, and here again, the threshold is very low. It is typically met, and especially in the case of software, it's under discussion whether it should be very, very low, because it's so hard to have prima facie evidence of patent infringement. Then you can go to court and ask for an ex parte order allowing your attorney, together with a court-appointed expert, to conduct some kind of dawn raid. So, and this application is typically granted, then the attorneys are put under an obligation of confidentiality, which is also enforced towards the own patent owner, though the attorneys are even not allowed to talk with their own client for this, as long as these proceedings are going on. And what happens then is that dawn raid is conducted. The court-appointed expert will collect the evidence he or she needs, and the court-appointed expert will write an expert report in which the evidence is described, and also the question of infringement is already assessed. And this assessment of infringement, this already will be part of later infringement proceedings. So it's like from later potential infringement proceedings, this aspect of valuing evidence, it is separated and conducted at a prior stage. And then once the expert report is communicated, well, to the defendant and to the plaintiff's, the patentee's lawyers, the actual fight will be about the surrender of the expert report, because so far the defendant hasn't really had any chance to defend. Yeah, he was not involved in the original application. The dawn raid was conducted, and now the defendant can argue, for example, trade secrets or any other confidentiality issues, and then dependent also on the outcome of the assessment of infringement, the expert report will be surrendered completely without any amendments, or partly blackened, or not at all. And well, then next slide, please. Now, once you have the report, the patentee can do with it whatever he or she wants. Especially, and now we're talking about the cross-border aspects of this, the patentee can use it as an evidence, as means of evidence in proceedings abroad, outside Germany. Another aspect as to cross-border obtaining evidence is that, for example, when source code is located on a server in a cloud somewhere outside of German territory, but if it is available from German territory, then the expert, the court-appointed expert, can ask the defendant to grant him access to these data, and then it becomes subject of the expert report. And further cross-border aspect is that this has happened rarely, but it is possible that you can ask for an inspection order in Germany because the German patent is likely to be infringed in Germany. However, if the subject of the of the assessment, like the source code or the blueprints or the production site, whatever, is in another country, then German courts would now grant the order, provided that there is some international treaty, some cooperation between the countries, which ensure that this German inspection order can be executed and enforced in another country. If this is provided, then you can also like have it conducted outside of Germany. And with this being said, I hand over to Mackenzie, I think, right?
Yes, thanks, Alex. So we have another poll question. Poll number 3, our question is, has your company initiated or encountered any cross-border evidence collection? Yes, no, or don't know. All right, thanks for those answers. It looks like we have about an even split across the 3 answers here. So we'll move on now to discuss 28 USC section 1782 discovery. Next slide, please. So US law provides for quite an interesting mechanism that can be used in the context of cross-border litigation and cross-border evidence collection. Specifically, 28 USC section 1782 provides the statutory basis for this kind of powerful discovery mechanism, and it allows for litigants who are involved in litigation in a non-US forum to obtain certain discovery under the broad US discovery rules for use abroad in the non-US litigation. For a variety of reasons, this statute is becoming more and more popular, more and more frequently used. And so we did want to provide an overview of the statute, its application, its application, and various considerations as part of our discussion today. So Section 1782 was promulgated with 2 aims. First, US courts wanted to provide assistance to participants in international litigation. And second, the US courts wanted to encourage non-US countries, by example, to provide some kind of similar means of assistance to US courts. Although the latter hasn't materialized, we still have hope. So a Section 1782 application would typically include a motion, an affidavit setting forth all of the relevant facts, and a memorandum of law. This will be filed with a federal district court where the person or the company resides or can be found. And this whole process can actually be done ex parte. So the majority of applications filed under Section 1782 are granted, at least in part, although the US courts do take a close look at the petitions to make sure that they are in compliance with the statute and to avoid overly broad requests. Next slide, please. So first, there are several threshold requirements for obtaining Section 1782 evidence. First, the respondent to the petition or the application must actually reside in the district where the request was made. Second, the discovery must be for use in a, quote, foreign tribunal. And third, the request must be made by the foreign tribunal itself or by any interested party. So if we look at the second threshold criteria, what exactly constitutes a foreign tribunal, it's good to look back at the legislative history of the statute itself. The statute was amended in 1964. The former wording referred to any judicial proceeding, while the amended wording refers to a proceeding in a foreign or international tribunal, which is quite a bit broader than any judicial proceeding. And when that change was made, the US Congress reasoned that the change would provide the possibility for US courts to assist in connection with administrative and also quasi-judicial proceedings abroad. And so this foreign tribunal has been interpreted to include, for example, international arbitration proceedings, and it has also been interpreted to include administrative proceedings such as patent nullity action or patent validity proceedings. In terms of the third threshold issue, who is an interested party, this is also interpreted quite broadly by the US courts. Of course, interested party would include litigants to the non-US proceeding, but the US Supreme Court has also held that the text of the statute plainly reaches beyond the universe of persons who are just designated as a litigant. And they've determined that any interested person is intended to include any other person, whether he be designated by foreign law or international convention, or someone who merely possesses a reasonable interest in maintaining or obtaining the assistance. And so interested party is interpreted quite broadly by the courts. In addition to these threshold requirements, there are several other factors that are considered before a court will grant a 1782 application. So one factor considered is, does the non-US tribunal even permit discovery of the kind of information that is sought? Or on the other hand, does this 1782 request, is it really kind of an attempt to circumvent restrictions or policies that are in place overseas? If the US court becomes convinced that the application is just an attempt to circumvent those kinds of restrictions from another tribunal, this would weigh strongly against the 1782 application being granted, unless, of course, there has been some kind of authorization from the other tribunal. Another factor considered by the courts is, would the non-US tribunal even admit the information into evidence? And so if the answer is no, as you might imagine, this would also weigh strongly against the 1782 application being granted. Another factor that the courts will consider is the cost or the burden of responding to these requests. And this can kind of present itself in a variety of forms. So one form would be US courts preferring more narrowly tailored requests in the context of Section 1782. So the US courts are more likely to reject an application or at least urge the parties to work together to narrow the scope if an applicant has made very broad requests for discovery and where the respondent has made some kind of compelling argument to the court that the requests are too burdensome. Additionally, courts have the power to shift the costs over to the petitioner to protect the respondent from any undue costs. And lastly, the courts will consider confidentiality or other protections or privileges that may apply to the documents or the information sought. The court may enter a protective order, which could ultimately restrict the usage of the information discovered, which could be a problem. And it may even deny the request to the extent the applicant cannot satisfy the court that the information would be sufficiently protected overseas. So those are some of the factors considered, and I just have a few final thoughts. First, surprisingly, the non-US proceeding does not even have to be pending at the time of the Section 1782 request being made in the US. It's possible to actually make a successful application prior to even filing the non-US action. Second, with respect to burden of proof, the requesting party has an initial burden of showing that it is entitled to the discovery, but once that burden is met, it shifts to the other party to demonstrate that allowing this kind of discovery would somehow disserve the objectives of the statute. Third, in relation to appeal, if the district court grants or denies this discovery, that decision is immediately appealable to the appropriate US Court of Appeals. And last, regarding the location of the evidence, there's actually currently a split of authority in the US Circuit Courts as to whether Section 1782 would even allow a party to obtain documents that are controlled by an entity in the United States, but that are actually located overseas. And the Second Circuit and the 11th Circuit have permitted this kind of extraterritorial application of Section 1782, and several US district courts have followed suit. So as a result, it may actually be possible to obtain evidence located outside of the United States through the US courts for use in courts outside of the United States, which is really an interesting result. Of course, in these circumstances, courts will still consider all the other factors I just mentioned before granting that kind of application, including the costs, the burden, and all of those factors. So with that, I will now turn it over to Helen to discuss how this process has been used in Australia and what the US or the Australian courts have to say about Section 1782.
Thanks, Mackenzie. So yes, so parties to Australian litigation have over the years tried to use the 1782 process to obtain documents, primarily in the US and not for extraterritorial sort of application, but then for use in Australian litigation. However, up until a few years ago, all attempts to use this process were not successful within Australia, with Australian courts restraining parties from using documents obtained via the 1782 process. So I guess what led to the court's change of heart it was actually the 2017 Levecki decision of the Federal Court of Australia. Well, a key reason was that the party in that case sought the Australian court's approval to apply under the 1782 provision for the production of documents relevant to the Australian proceedings. Previously, Australian courts had on a number of occasions issued anti-suit injunctions on parties, preventing them from proceeding with 1782 applications, primarily because the application was made without the Australian court's prior approval, which the Australian court considered to undermine their supervisory and case management functions and authority. So helpfully in this Levecki decision, the Federal Court provided guidance as to what factors would be relevant to the court's consideration of whether to endorse the use of the 1782 process. And you'll see many of the factors are very similar to the sort of factors that Mackenzie's just talked about in terms of the actual proceeding in the US for the 1782 application. So the factors which the court said are relevant for endorsement by the Australian court of a 1782 application are on screen, and they were the importance of the material sought to the party's case, whether there are other methods available for obtaining the material, whether the material sought encroaches upon or undermines some important procedural limitation in Australia. And an example given was the unwillingness of Australian courts to permit what we call fishing expeditions. The costs involved in the process for the parties to the Australian proceeding, whether the cost is a proportionate burden in relation to the significance of the material. So you can see there's a weighing up exercise that the court does there. Whether the proposed proceeding in the US would be considered to be frivolous or obviously doomed to fail. How long the 1782 application is going to take and what impact that might have on the timely preparation of the matter in Australia for hearing. And also whether there's any need to impose conditions upon the endorsement of the proposed application so as to address any of the issues I've just mentioned. Now, in Levecki, the court was satisfied that each of these matters was adequately addressed or favoured approving the 1782 application. The court placed just one condition on the application. They required the applicants to provide the respondents with the proposed application and supporting material prior to filing in the US District Court. Now, this requirement placed the respondents in a similar position to the one they would have been in if the court had made orders for discovery from a third party under its own rules. So the key takeout is that if you want to use the 1782 process to obtain material for use in an Australian case, it's absolutely crucial to apply to the Australian court for their approval. If you don't, you are at risk of an anti-suit injunction. This practice also permits the Australian court to exercise supervision over its own processes, which obviously it considers that's appropriate to do so. So since the Lebecki decision, approval has been sought on a number of occasions to make a 1782 application, with sort of some success, some not great success. So the same judge that heard the Lebecki case actually heard another 1782 application in the same year and actually granted it. But in another case, the court didn't approve the making of a 1782 application for a number of reasons, including because the parties had already spent millions already on discovery and because the oral depositions sought were considered to be unnecessary, given that there'd been an undertaking from the other party to make all relevant witnesses available for cross-examination at the hearing of the Australian case. So that's where we'll end it in relation to the 1782 applications. Please do submit any questions that you have via the Q&A function. And on that note, I'll hand back to Marcella for the last poll and to wrap it up.
Thanks, Helen. So for our next poll question, I think it's the last one, is there a protocol in your company for cross-border litigation or evidence collection? Closing. So now showing the results. Oh, most of you said no or do not know, but we did have some yeses, especially for cross-border evidence collection. Thank you for submitting your answers. So conscious of time, I think I'll now read the CLE US code on screen, which is NM110321. Let me repeat, NM110321. And we do have 3 minutes for questions and answers. So if you can use the Q&A button at the bottom of the screen to submit a question, we will then answer, I think, at least one question. Thank you. Thank you, everyone. So I'm going to start with the following question, and I think I will direct that to everyone but Mackenzie. So we have heard about a 1782 procedure. Are there similar procedures in Germany, Australia, I think Helen covered, China, and Brazil? Alex, do you want to start?
Yeah, and yeah, I can be quick. Now in Germany, we do not have this kind of altruistic proceedings for obtaining evidence. What we have is what I've spoken about, proceedings which require a German patent to be potentially be infringed in Germany. And then, of course, if you obtain evidence from this, as a side effect, you can use it for litigation abroad, but we do not have essentially discovery or these proceedings for only for using the evidence in another state.
Thanks, Vincent. You're on mute.
Sorry about that. So for China, as a signing country of Hague Convention, we do have some regulations regarding this. So China allowed the parties to collect evidence either 2 ways, either the overseas jurisdiction to collect evidence in China, or we reach out to collect evidence overseas. But the approach has to go through the DOJ in China, and then Supreme Court, then local court, and then do the local evidence collection. And any individual or foreign entity evidence collection forbidden by China.
Thanks, Vincent. Thank you. Yeah, for Brazil, we don't have anything similar. I think we are similar to German somehow, because we do have proceedings for producing evidence which can be used abroad, but not the 1782 type. So with that, I think it brings us to the end of the session today. We are hitting the hour. So I want to thank all our speakers and our participants in today's webinar for joining. If you have questions that have not been answered today, please feel free to email us. Any of us will be glad to assist you. And well, bye-bye. Stay safe and stay well. Hope to see you in our next webinars. Bye-bye.
Thank
Thanks
you.
to
Bye.
everyone.
Hi, thank you.